Welcome back to another episode of Employment Law After Hours, and boy, do we have a lot to talk about today. It's been quite the week since Donald Trump's presidency began, and he's made three major moves already that are taking the employment law world by storm. As you may recall, our channel did an episode just a couple months ago comparing what a Trump versus Harris presidency may look like. It's looking like a lot of our predictions that we made during the Trump episode are actually starting to come true, many of which were rooted in the Project 2025 analysis that we performed. So what are these three big changes? I'm going to give some highlights and 30,000-foot views of each of those here today in this episode. However, please note that many of these are going to require their own individual episodes as they're rooted in significant substance as well as potential consequences for both the public and private employer sectors. The three changes we're going to cover here today are: number one, the U.S. government, particularly the executive branch and its agencies, have implemented a hiring freeze on all federal agencies that are controlled by the executive branch. This was implemented as a result of one of Trump's executive orders that he implemented within a couple days after his inauguration. The second topic we're going to cover here today is Trump's executive order revoking a 1965 executive order that required affirmative action in federal government contracting when contracting with private sector federal contractors. Specifically, Donald Trump revoked Executive Order 11246, again implemented in 1965. This revocation is going to have significant consequences on federal government contracting, as well as begin to shift into the private sector and what we expect to see in the coming months regarding the EEOC and other discrimination changes that Trump hopes to roll out into the private sector, thereby affecting private employers. The third major change came in the form of Trump's nomination as to the EEOC's acting chair, which will now be Andrea Lucas. As you may know, the EEOC is the subdivision of the executive branch that is primarily tasked with investigating and enforcing discrimination laws both in the public and private sector. As we'll discuss here today, the person who's responsible for the EEOC primarily shapes its agenda and its policy goals, for their term. We're going to dive a little bit here today into what we expect to see from Andrea Lucas based on some statements she's already made thus far. Before we jump into these changes that we've seen, it is important to note that these really are going to affect, to a great extent, both public and private employers. However, we don't think the changes are done, and we don't think the enforcement of these executive orders and other proposals are fully done being fleshed out, right? We expect to see more changes over the coming months, so we will have more information on those changes as we receive them. Let's start with the hiring freeze. Reading directly from the executive order that Trump issued, Trump has stated that he hereby orders a freeze on the hiring of federal civilian employees to be applied through the executive branch. No federal position that is vacant at noon on January 20th, 2025 may be filled, and no new position may be created except as otherwise provided in his executive order. Trump's executive order basically states that any unfilled position that falls under the executive branch that was unfilled as of January 20th cannot be filled moving forward without some sort of other order overturning this executive order. So if a candidate was interviewing for an open executive branch position but had not yet been hired by January 20th, it's very likely impossible that their interview, process and even potential contingent offers of employment are going to be revoked or ended. This is going to have a huge impact on the thousands of candidates that have applied and continue to apply for open executive branch positions in the federal government. Of course, two exceptions that the executive order provides for are open positions within the military and any open positions dealing with border policy enforcement. Those are two areas that the Trump administration will continue to hire for and are otherwise accepted from this executive order. This freeze also has the potential to really slow down certain agency actions within the executive branch. If you're sitting there and you say these agencies already move as slow as it is, well, it's typically as a result of understaffing and other bureaucracies, of course, but by having this hiring freeze in place, the understaffing problems are not going to be able to be resolved, and we could potentially see some slowdowns in divisions such as, Health and Human Services, Social Security Division, potentially even passport processing. If you're a candidate that was applying for an open executive branch position and you've had your contingent offer or maybe even firm offer revoked, it's important that you reach out to an attorney to discuss some potential legal action you may be able to take, such as maybe for breach of contract as a result of this revocation. Let's now shift to Trump's executive orders revoking Executive Order 11246 that's been in existence since 1965. Under the original Executive Order 11246, federal contractors, meaning those companies that contracted to perform services on behalf of the federal government, particularly the executive branch, were required to implement certain affirmative action programs in their hiring process, as well as ensuring that discrimination laws were fully enforced within their private organizations. Of course, meaning no discrimination on race, gender, disability, age, veteran status, things of that nature. With the two executive orders that Trump issued last week, both on January 20th and January 21st, not only has Trump revoked that existing executive order for federal contractors, but he is now stating that federal contractors cannot use affirmative action policies in any hiring decisions that they make. It's important to note that most federal contractors already have these affirmative action hiring processes rooted into their hiring system because of this 60-year existing executive order. Federal contractors are going to need to speak with their attorneys to otherwise begin to unravel those hiring processes and ensure that they're complying with these executive orders, which are enforceable against federal contractors, particularly those that have contracts with the executive branch. Trump has essentially ordered that federal agencies, particularly the Federal Contract Compliance Program, immediately cease from promoting diversity, holding federal contractors and subcontractors responsible for taking affirmative action, and allowing or encouraging federal contractors and subcontractors to engage in workforce balancing based on race, color, gender, sexual preference, religion, or national origin. It's important to note that this shift in affirmative action enforcement does not apply to private employers unless they have a federal contract, particularly with the executive branch. However, what these executive orders do provide is they want to see policy and shifts among the executive branch to begin enforcing and otherwise eliminating DEI programs from the private sector. DEI stands for diversity, equity, and inclusion, and it's really been a form of programming and policy that has existed for a couple decades, but has rather picked up steam over the last couple of years as private employers begin programs, especially since 2020, to really highlight diversity and offer programs that further diversity in workforces. It's important to note that many shareholders have called for such DEI programs when investing in companies. The DEI system was originally implemented in investment banking to really gauge certain parameters of businesses before they're invested in. Regarding private sectors, Trump is not saying that it is currently illegal for a company to employ a DEI program. He's implying it, but we'll get to that difference here in a second. But what he is calling for with private sector employers is for his government employees, his agencies, to identify key sectors of concern within each agency's jurisdiction for sectors that typically implement DEI programs. He is also calling for the identification of the most egregious and discriminatory DEI practitioners in each sector of concern. Finally, he wants plans and practices developed for steps and measures to take to otherwise root out DEI programs in the private sector. To the extent the Trump administration would try to take any action against the private sector when it comes to DEI programs, I really think those would be faced with some pretty severe legal challenges in the court systems. First, it raises First Amendment concerns for businesses as it comes to their education and policies that they really want to promote among their workforces, particularly if they're not making any sort of adverse decisions against any employees or candidates on the basis of any protected class. Second, as we saw under the Biden administration, the U.S. Supreme Court has really taken steps to curtail the ability of the executive branch agencies to implement widespread, overarching, policies and rules for the private sector. We saw this with the attempt of the FTC to ban non-competes nationwide. We've seen this with the attempt of the Department of Labor to dramatically increase the minimum salary to be an exempt employee. And we've really seen courts shoot down these overarching attempts from federal agencies to really put extreme, broad, overarching limits on the private sector. The impact of the affirmative action reversal for the federal contractors really cannot be stated enough in a single episode. This is something that we're going to have to cover in a subsequent episode that really goes into the details and nitty-gritty, if you will, of what those affirmative action programs required among federal contractors. Finally, for the third point we're going to cover here today, let's move to Trump's appointment of his acting chair of the EEOC, Andrea Lucas. As you may know, the EEOC, otherwise standing for the Equal Employment Opportunity Commission, is otherwise responsible for investigating and otherwise potentially enforcing through litigation certain violations of the Civil Rights Act and other relevant employment laws in both the public and private sector. Many employers are aware of the EEOC as they're the ones that they receive the letter from when a candidate, employee, or former employee has made a complaint of discrimination against that company. They often receive the letter in the mail from the EEOC saying, hey, we're investigating this charge, and ultimately when that investigation process is finished, the EEOC may make the decision to bring a lawsuit against that company on behalf of the employee or candidate, or otherwise provide that candidate or employee with a right to sue letter, allowing them to bring their own civil action against the employer in court. Under many laws, it's a necessary step before you're ultimately allowed to sue an employer in federal court for discrimination. Typically, the person assigned to the EEOC, when the change of guard occurs right at the presidency, is not one that's often covered in large-scale news. It's rather typically a figurehead position with a agency that primarily just moves forward as it always has. This appointment of Andrea Lucas is pretty important, and I want to read to you a quote that she provided as to why this is so important. Andrea Lucas is quoted as saying that she looks forward to restoring even-handed enforcement of employment civil rights laws for all Americans. Her priorities will include, quote, rooting out unlawful DEI-motivated race and sex discrimination, protecting American workers from anti-American national origin discrimination, defending the biological and binary reality of sex and related rights, including women's rights to single-sex spaces at work, protecting workers from religious bias and harassment, including anti-Semitism. That's really a lot to unpack. But what she's essentially saying is she is going to utilize the EEOC to investigate private employers and potentially public employers as well, who continue to utilize DEI programs to make employment law decisions. What that's essentially rooted in is the opportunity of the EEOC to investigate and otherwise bring enforcement action against what's otherwise known as reverse discrimination. What she's essentially saying is, the Trump administration believes that, white Americans, people are American in general, have been discriminated against by the private sector employers. I don't know where that data is really coming from. It's not something that's really seen as a large-scale problem among employment attorneys, but hey, I'm sure there's cases out there. But what she's saying is it's going to be a priority of the EEOC moving forward to otherwise target these, quote, reverse discrimination type decisions to the extent that they're made by private employers. Again, at the end of the day, it's always been illegal for an employer to make a hiring, termination, or otherwise adverse decision based on someone's race, gender, national origin, disability status, etc. And nothing here is changing with this executive order or this appointment of this individual. If previously a candidate or an employee was discriminated against because they're white or because they're a man or because they're an American, they could have always sued under the laws of the U.S. jurisdictions. That's not changing, and that hasn't changed. That's always been the case. But what Andrea Lucas is saying, it's now going to be a priority to really find those cases and enforce those cases of, white American discrimination. What this really is a warning to private sector employers that to the extent you're using DEI programs when making hiring, promotion, or termination decisions, you could be held liable under the Civil Rights Act. But again, that's always been the case. Regardless, what I'm hearing from other employment attorneys is that we are going to continue to expect to see an increase in discrimination filings, an increase that really we've been witnessing since back to 2020. I expect to see more discrimination and harassment cases hit the courts over the next 4 years. But again, it's tough to say whether that increase is a result of the pattern we've been seeing for the last 4 years, or will the increase continue to be as a result of this appointment of this new EEOC acting head? Regardless, if you're an employer who has received allegations of discrimination or harassment or a letter from the EEOC or your relevant state agency, it is important that you retain a employment attorney to help you investigate and respond to those allegations. Ignoring such allegations, even if nothing formal has been filed yet, can really increase an employer's liability in the event such cases are brought in court. Well, that's all I got for you today on this quick introduction to the three major employment changes we've seen just in the first week of Trump's presidency. Stay tuned to this channel for further updates and other changes that I'm sure will be coming over the next couple months from the Trump administration. We'll see you again next time.